Thank you and welcome to Panel 4, the importance of the Tribunal's archives. My name is Thomas Osorio. I will moderate, and I must say that it is my distinct pleasure and honor to moderate this panel because I used this information and facilitated the handling of the archives of the ICTY for about 14 years. And so I'm also here to tell you that this is information that is valuable, and you as practitioners must find the appropriate ways to access this information. The task of this panel is not only difficult because it's nearing the end of the conference, but because somehow we would like to complement or tie in all the important notions and concepts that were discussed earlier. And my first question would be, is there any remaining questions from the last panel that needed to be asked, or can we leave those for the end? Good, we can leave them for the end, very good. Allow me a few initial remarks, because I think at this point it's very, you did, I'm sorry, madam, I'm sorry, madam. Can we get a microphone?
I apologize for interrupting this session. I wanted to ask, I'm somewhat confused with this decision of the Court of Bosnia and Herzegovina to anonymize the convicts and the accused. What is the purpose of the trials and the prosecutions? Who will benefit from this confidentiality, and who will benefit from not disclosing the identity of the perpetrators to the public? Where are the victims in this context? Are the victims completely disregarded and unimportant? The prosecutor is doing his job, the defense counsel is doing his job, they are arguing their cases, and someone will win. Is that the purpose? This is very strange for me. I find it hard to accept this as a victim. I think if this practice is adopted, then you should stop spending the money, and you should stop indicting persons and trying cases. And we still haven't raised that issue. We know that the ICTY referred to the Court of Bosnia and Herzegovina some 800 cases that had been investigated, and that the court was to arrest some people and bring them to justice. We still haven't heard any information about any persons from those lists tried before the national judiciary. How long are the victims going to wait? 56 people from my family had been killed. I am left without a husband, without my children, without cousins and close relatives. How long will I wait to see that justice? And that is the only thing that I live for. I want to see this country in future with my grandchildren living in it with hope. If all this information will remain anonymous, then all this work has been done for nothing, I think.
Going back to the importance of the archives, I think that it is essential that we provide a definition, that you understand what is meant by the archives of the ICTY. The tribunal records are divided into three categories. Those are the judicial records that are directly related to the cases that are generated. There's video, audio, as well as transcripts. There are records which are not a part of the official judicial record, but are generated in connection with those cases. And there are the administrative records of the tribunal. The most important part of those records, which I believe are the most interesting, of course, are those that are dealing with witness statements and other evidence that may be used in domestic prosecutions. The tribunal has long assisted the national jurisdictions by providing them. I do not wish to speak on behalf of the ICTY in this regard, but I am quoting the information that has been provided by the ICTY related to these documents. But what is important is that this information is, the decision about this information is underway. Certain decisions have been made, and there will be subsequent decisions related to the archives in the near future. But I think it's very important to distinguish between the information which is now being held by the court or the registry and the information that is being held by the office of the prosecutor. Today we have panelists, and we'd like to discuss or to provide you with the opportunity also to ask questions about how will you, as potential users of this information, practitioners, access this information. And I think I could start with both Saša and with Elisabeth. I think if you could perhaps, as potential facilitators or the national level, well, but I think that Saša will explain how this information may be indeed made available to you. Saša?
Good afternoon, everyone. Before we begin this discussing this very important issue, the legacy of the tribunal and its archives, we should raise several important issues. The accessibility, availability of the archives of the tribunal, and the usability of that material, and the protection or preservation of that material. The tribunal's archives, when we talk about those archives, we often refer to the ownership of the documents. We have to divide two key issues. First issue is the material that was generated through the work of the tribunal, including financial, administrative, and other records. That is the ownership of the tribunal, and the tribunal can store it in a safe, in some kind of a storage place in New Jersey. It would be okay. But certain materials that were generated during the prosecution of the war crimes, like evidentiary material and testimonies, that material has to be considered seriously. Eric Cutler and Mr. Patterson gave two proposals. I don't want to talk about the modalities of the transfer, but ask several questions that remain unanswered but are very important. First of all, the archives of the tribunal include an extensive body of documents. These records are managed by the archivists of the tribunal, Madam Elisabeth Emerson. Now, this concerns the persons that are managing the archives. How are we going to treat these archives? We were witnesses of one unpleasant event from 2009, when more than 1,000 pieces of evidence or evidentiary materials were destroyed. More than 1,000 artifacts were destroyed because they were health hazard. And it was one harsh decision made by the tribunal. The archivists of the tribunal trained sufficiently in terms of the cultural and historical context about the materials that should be preserved and kept permanently. What are the archives that is not classified as something that should be permanently stored? If we are discussing, if we are talking about millions of documents, what is that final number that will remain as permanent documentation of the tribunal? Are these persons consulting each other as to which materials should be kept? If they have certain doubts what to do with some materials, whom do they talk to? These are some very important issues. Then there's the issue of availability of the archives. there is a large body of documents that were digitalized, and we need to also discuss the access to these digitalized archives. We should not build a place where the archives will be stored and preserved in terms as a museum, but something that people can access and use, even for educational purposes. If we want to learn facts, and if we want our children in their education to learn the facts and to receive answers about who did what to whom and where, we must ensure access to that information so that it will be used to draft books. And another issue that has been raised by historians and a professor at the Michigan University who raised the issue of access to this material by the scientists. Then there's the museum and pedagogy activities, namely exhibitions showing documents about the historical events that occurred in this country. So this discussion is very broad, and it also includes the issue of protection. Digitalized material, it's no longer just to digitalize something and store it. We need to also consider curatorship. You must know that we don't have floppy disks where you can store some materials. You need to these formats change so that in 50 or 100 years we cannot even anticipate in what form these archives will be kept. We must ensure the protection of hard copies, but also digital copies have to be migrated from one platform to another almost on a daily basis to make them available to persons who will search them in 100 years from now. So we have to first discuss whose archives are those. As a former archivist, I don't think it is the ownership of the United Nations, but Gabrielle McIntyre can tell us who is the owner of these archives. Are these yours or ours?
The tribunal is a subsidiary organ of the Security Council. So as a subsidiary organ of the Security Council, the work product of the tribunal is owned by the United Nations. So the United Nations asserts ownership over the archive. And basically, if you understand the archive, I know the importance to the region is the judicial records and the facts that were established by the tribunal through its judgments. But the evidence in the archive comes from many different places. So it doesn't just come from the region, it comes from many states who had evidence which they could share with the tribunal. Their intelligence information that they gathered during the conflict about what was going on. Many other entities provided information to the tribunal. So the information is actually coming, it's international. It's not just national information that came from people in the region. And in obtaining that information, the tribunal gave various undertakings to the providers of information. And basically, it undertook to protect the identity of the providers of information, especially when it came to third states that were providing information to the tribunal. So it's basically the concern about maintaining confidentiality. That means that the tribunal is given the responsibility, or the mechanism which will take over from the tribunal, for maintaining and preserving the archive. But in the Security Council resolution that established the residual mechanism, the tribunal was also instructed to make sure that the information that it's collected during its work would be accessible to people from the region and from all over the world that wanted to have access to it. So the Security Council resolution instructed the tribunal to examine the feasibility of establishing information centres and to make sure that the public record would be accessible. The Security Council statute that established the residual mechanism also placed an obligation on the residual mechanism that wasn't placed on the tribunal, and that was to cooperate with national judiciaries in requests for assistance. Now, the tribunal gave that cooperation when it began to transfer 11 BIS cases through its Office of the Prosecution and its chambers. But the right of national judiciaries to actually petition the tribunal directly to get materials was really the brainchild of Judge Foucault, who basically understood that the work of the tribunal was to be limited, that most of the work would be done by national judiciaries, and then there needed to be an objective way that prosecution and both defence could access confidential materials of the tribunal. So the emphasis that the tribunal and the MICT and the Security Council and the UN is placing now on the archives is making sure that they're accessible to as many people as possible and in a form that will be usable to them. And with respect to your question about, are we keeping the information? I mean, basically, anything that went into the judicial record will be preserved. And I think, but the prosecutor has its own huge evidentiary collection that many of the documents in that hasn't been placed into evidence. And those artefacts that were destroyed by the prosecution were part of that evidence collection. Although they had taken photographs, they'd preserved them in another way so that they could use them. They had another evidentiary form of the actual physical object that they could use. But they are still coming to terms with their policies in relation, to that evidence collection. Their thinking is it should be retained as a whole, and that's a basic archival principle, that archives should be retained as a whole. And if you understand the archives as it's the work product of the tribunal, it's the day-to-day work of the tribunal, it's the international community's reaction to the conflict through the organ of the Security Council.
I think that also Elisabeth might be able to add the practice, other practices with similar collections.
I might need to explain quickly why I'm on this panel. Our organization is running a program on archives and dealing with the past, and we are working in different contexts with different transitional and dealing with the past mechanisms, truth commissions, tribunals, on the issue of archives, and also on how do you document and how do you use archives, and how do you open it and make it accessible to a broader public. And I would like to broaden a bit the view, and there is a discussion, an ongoing discussion on having international judicial archives somewhere, most probably in The Hague. And what had been said by Gabrielle is to have this material in one place and see it maybe a bit broader as somehow a heritage which belongs not only to one country, but to the community, the world community as a whole, and where the access is possible not only for victims, for judicial authorities, but for research, for a broader public, and that this is guaranteed not only to the archives of the ICTY, but also the archives maybe of the ICTR. The archives of the Special Court for Sierra Leone have been transferred to The Hague. There was the whole discussion there as well, where do they belong to? And in the end, the decision was taken that the safest and the best solution is to have them in The Hague. Of course, and this is really, really important, with all the possibilities of access of the people concerned, with different levels of access to different information, more or less confidential information. And this is then up to the reference services, which is handled by professional archivists. So there is a discussion which goes beyond the archives of the ICTY, which is still a discussion, but just to broaden a bit the view on archives of international and mixed tribunals is ongoing. The other issue is how is an archive used? And we have heard a lot in the previous panels about education, about excellent programs that are already going on. And Alma has talked about how she is already using now material from the archives. There's a lot of material already available. I have seen things done by the outreach, which actually I'm also using in lectures in Switzerland to teach students there about what is going on. So there is a lot is available, and it can be used in education programs. There's a lot of experience in Latin America on how archives of truth commissions, judicial archives of national judicial authorities are used to make it accessible to in education programs, to the media. And I think this is one of the issues that should also be discussed. How do we use the material which is open to the public and use it also to foster dialogue and to bring also together or to discuss about contested histories. This is done in other contexts as well. Contested histories is not something that only exists here. We had it in other contexts, and archives are used and can be used to foster these discussions. And I've just seen this really impressive picture here that was on this postcard. And I think things like this can, and that had been mentioned in panels before as well, it can personalize stories and it can touch emotions. And I think this is something which, even if an archive looks boring from the outside, it contains a lot of material that can really touch people, where you can tell stories about individual victims. And this is something I think we should think about, and also look at other examples, how it has been done in other contexts.
I think it might be a good time actually to pass on to the deputy mayor, because the mayor of Sarajevo has made an interesting proposal that is under discussion. Please, you have the floor.
I would like to greet all the participants in this very important gathering. I will try to touch upon the topic of this panel, the importance of the archives of the ICTY. And let me say in that regard that from the perspective of the town of Sarajevo, the importance of the archives have been long recognized, which is also reflected in our communication with the ICTY, where we expressed our willingness to be a host for an institution that would allow access to broader public to the archives of the ICTY. We are, of course, aware of the fact that these are extensive materials, and that is why we carefully followed discussions and debates about the final fate of the ICTY materials. Today we received a handout titled ICTY Global Legacy Assessment. I would like to refer to a few sections of that material. I, of course, support everything that was said before pertaining to the manner in which the materials have to be handled and the type of services offered by certain institutions or agencies that would be entrusted with the management of the archives. What should be highlighted here is the motive. Why are we thinking about this, and why do we want this? Potential beneficiaries of these centers and the information kept therein. Can we have a microphone? Good afternoon, my name is Sejdalia Gušić. I have something to say on behalf of the local community. About panel number 2, I have to ask something. During the panel number 2, we spoke about the mechanism that should become operational in July next year, and its mandate will be renewed every 2 years, if I understood it correctly. The resolution of the Security Council from late 2010 decided that the archives of the ICTY would be managed operationally by the mechanism that will be then subject to biannual reviews. Is there any limitation placed on the number of renewals for this residual mechanism, or did the resolution already decide on the ultimate location of the archives of the ICTY? Thank you for your question. And if I may add something else, I will, of course, allow other colleagues, archivists, to say something. Pertaining to the ownership over the materials, Mr. Madacki inspired me to say a few words about that. In 2008, actually late December 2007, there was a delegation headed by Mr. Tetler and I believe Ms. Cecilia Aptel from the archives. The archivists of Bosnia and Herzegovina shared a unique position at the time, and if you allow me, I will read something about the ownership over the archived materials originating from Bosnia and Herzegovina, but kept at the ICTY. Please just keep it short. Under the provisions of the national legislation and international legal instruments, the principles of ownership or use of archives have been clearly established. The principle of functional pertinence and unity of archive materials are promulgated, meaning that the archives are the ownership of the area where the materials originate from, and something that was taken from a certain territory is to be returned. It is therefore clear that the archive materials used or in use before the ICTY are the ownership of Bosnia and Herzegovina, and therefore upon the completion of the activities of the tribunal, they should be returned to Bosnia and Herzegovina or the institutions of Bosnia and Herzegovina where they were taken from, as a valuable historical legacy that belongs to Bosnia and Herzegovina. I would like to hear comments from Madam Baumgartner about this. Thank you for your question. I believe it is very important, and I'm really glad to have Madam McIntyre here with us. She deals with these issues, and I believe she will be able to answer your question.
Sorry, thank you. With respect to the mandate of the residual mechanism, it basically has a mandate, the first mandate for 4 years, and then to be reviewed every 2 years. But we anticipate that it will have a fairly lengthy life because of the mandate it has, the continued protection of witnesses and victims, the continued monitoring of enforcement of sentences. It also has a function to initiate contempt proceedings if anyone violates protective measures. We don't know how long it will last for, but while these people are still living, there needs to be some mechanism to deal with issues that may arise. So I know in the delegation you were speaking about that came and visited, they estimated that in about 2090, nobody would still be alive left over that had been involved in some way in the tribunal proceedings. With respect to, you asked Elisabeth, I think, to deal with the ownership, of the archive material. One of the reasons why the UN asserts, ownership over the material is it's part of if it's part of the judicial record, you can't sort of take it out of the judicial record. That would violate the integrity of the judicial record. A lot of the evidence that the prosecution has that hasn't been used in evidence, they're still developing their policies as what they're going to do about that. I'm not sure how much of the documents they have or that we have are originals. I read in some, I think the Kettler report or one of the reports, that a lot of the material that the tribunal had was copies of the originals, and the originals, were returned at the time. So I'm not sure how much of the material is actually original, but I'll let you. That's that. Thanks.
I agree for original documents or exhibits that are important for the history of the country, that there must be found a solution. But it's important to keep the archive as a whole, whether it's done with copies. I think one has to check really what we are talking about, which records, which artifacts you are referring to, and probably that will be something that, as you said, must be decided together with the national authorities. We are, of course, not only talking about Bosnia, but also about other countries that do have an interest to get these things back. And then, above all, the protection of the persons involved. This is the most important, that this is kept confidential, what has to be kept confidential.
Good evening. My name is Izet Šabotić. I'm the director of the archives of the Tuzla Canton, and I am the professor at the School of Philosophy in the Tuzla University. For some 25 years, I've been working in this field. I feel a professional obligation to join in this discussion about this very important topic, to share my views concerning this topic. Colleague Gušić made some remarks, and I will try to briefly respond to what other colleagues said, colleague Madacki, colleagues Gabrielle and Elisabeth. What is crucial, in my opinion, and it has to do with the archives of the ICTY, is the respect of and adherence to the international documents that clearly defined this issue, and through our contacts and conversations, we always insisted on adherence to these documents. These documents treat several crucial issues that were raised here: the issue of ownership, protection, and use. I am not so sure that what we heard today offers the best answers or solutions. Why? Because in resolving this issue, we should involve the institutions and professionals. Institutions such as International Civil Council as the umbrella association, and national institutions from the territory of Bosnia and Herzegovina. If we involve such institutions, we will come closer to the resolution of these issues. Saša probably said, usage and protection. We should always say first protection, then usage. How to use practically these archives. You must understand that this is a part of our memory, and today and in 5 years and in 150 years, we want to have clear mechanisms that will make this memory of ours available in the next 100 years or more, because we need that information for the processes that will be initiated in different institutions in Bosnia and Herzegovina. But these archives are important for the science and for other sectors in the society. I entirely agree. I never really focused on what should come first and next. I always spoke from the perspective of the beneficiaries and people who are most interested in gaining access to the archives. Here we discussed the access that should be made available to the interested parties. Safekeeping of the material will be, of course, discussed through the residual mechanism as well, including International Archives Council in this discussion. I'm first of all surprised to hear that they have not been involved in this process, although they are familiar with the topic. You raised an excellent question as to why International Archives Council is not joining in these processes. We should seek their opinion as well. This is an association that has no authority other than advisory, and they provide advice. They don't have a legislative or executive powers to mediate or regulate something, but to provide opinions and advice on certain issues. It is in the statute of ACOM and IFLA and ICA. But you know, we archivists, we tend to elaborate too much when we talk amongst each other. We should give floor to others to join in.
There is actually a study provided by the most known archivist. She's the president of the Human Rights Working Group of the International Council of Archives, and she has actually proposed this idea of having judicial archives in maybe The Hague or another place. The Hague already has a lot of archives of international tribunals, of the International Court of Justice. The ICC is there, and the idea comes actually from a member of the ICA for different reasons, to foster research, to actually secure the archives in a very, very professional way, handled by professional archivists, and have them in one place. Handle that this kind of archives is really, really expensive. It needs a lot of resources to secure them properly, to have the backup done properly, and just also to have all these archives physically in one place, which doesn't mean that, I mean, having them physically in one safe repository doesn't really say anything about who is then the owner and who has access. This is another question. So there is advice by the ICA, and I recommend the study.
Advice.
It's advice. It's advice. They, as you said, they don't have a decisional power, but there is advice from the ICA.
Thank you, Elisabeth.
Good evening. My name is Janko Velibirović, Republican Center for Research of War Crimes in Banja Luka. I will follow up on what my colleagues said about the legal definition of ownership and the handling of archives. In 2008, the presidency of Bosnia and Herzegovina ordered or advocated that idea to start with the resolution of this problem through the archives of Bosnia and Herzegovina and the Ministry of Justice. The Republika Srpska, actually the National Assembly of the Republika Srpska, considered this idea, and the point of view of the member of the presidency from the Republika Srpska who blocked this order, and it was considered to be the protection of the national interest, and the position of the government of the Republika Srpska is to return the archives to those from whom it was seized. In the years after the war, the Hague Tribunal, with the assistance of SFOR, several times entered the facilities in the Republika Srpska from where they seized certain archives, and took those archives to the Hague Tribunal. Those archives included a lot of materials that were not included or used during the prosecution of cases, but were important for the functioning of the archives in the Republika Srpska, in terms of one's affiliation with certain military units and the exercise of certain rights arising from that membership, and some materials from the television, radio and television of Republika Srpska. They are no longer available to us because they are still in the Hague Tribunal. We want these archives returned to the Republika Srpska. There was a proposal to keep the archives in Sarajevo, for Sarajevo to be the center if the archives will be returned to Bosnia and Herzegovina. Then we proposed that there be two centers, one in Banja Luka, one in Sarajevo, so that Sarajevo takes what it belongs to it. We made the similar presentation at the previous conference in 2010, and we will reiterate the same opinion. We just want the archives to return to their original owners. Thank you. Thank you for allowing me to speak again. I think that these three panels have departed from the very essence of this conference. The archives that were generated in the ICTY is of central importance. We know that these archives came into existence based on the statute and the conventions and the rules governing the work of the court. These archives were obtained from various sources and used as evidence. The archives also includes the evidence used by the prosecutor's office documenting war crimes and genocide, and it can have the character or nature of public archives. Archives that came into existence upon the order of the prosecutor or the court. it should belong to Bosnia and Herzegovina. In 2005, and those of you who work at the ICC know that the ICC, as of 2005, initiated a series of expert researchers on this topic. I would like to quote one of the conclusions of those researchers: research of modality of transfer of archives of the ICTY within the national jurisdictions of in the regions by the regional office of the UNDP in Belgrade with the assistance of 4 regional offices. This research resulted with the recommendation, which is the product of opinion of a large number of experts, that the archives of the court upon its closure in The Hague should be preserved in Sarajevo, in Bosnia and Herzegovina. The reason for this recommendation is the fact that the Court of Bosnia and Herzegovina has a section for war crimes, which came into existence in 2004 and 2005, which shall continue with the remaining cases and prosecutions of thousands of cases, 16,000 cases to be more specific. Therefore, this section is the legal successor of the court or tribunal. End of quote. This conference should therefore give recommendations. Now it's too late, because the decision, as we receive the information, the decision has been passed in the Security Council and it will be implemented. However, Bosnia and Herzegovina must become the formal owner of the archives for only one reason. If someone thinks that the transitional justice will achieve its purpose and the war criminals remain unprosecuted, I come from Srebrenica. I every day look at the man who has taken my father off the truck. My father was 80 years old, and my father has never been found ever since. If that is transitional justice, then you should tell it to my face. We don't have so much time. You should have anticipated different opinions. If I may say one more sentence, this is a professional issue, and the professionals should deal with this issue involving all relevant institutions in Bosnia and Herzegovina, primarily scientific and legal institutions, religious institutions, police authorities, and other organizations for the victims, for the benefit of the victims. For us, victims of the genocide, the archives are very important for the historical researches and to show how seriously the human rights have been breached, so that Srebrenica does not happen again. It is important for our families and others who need to deal with these events and with what happened in the region. The governments in the region can progress only if they admit the crimes and apologize, and only in this way they will successfully deal with the past and build democracy in their countries. I know that there are other interested parties in the archives and the legacy of the ICTY, and their right to access these archives and this legacy should be also taken into account.
Good afternoon. My name is Živanović. I'm the director of the Historical Archive Sarajevo. When we talk about the takeover of archive materials by Bosnia and Herzegovina, this requires certain conditions, and it is very expensive. We are directors of various archives. We are well aware of how difficult it is to place archives in a suitable facility. Currently, there is no facility, physical facility, space, building and technology for storing this amount of materials and preserving them. It would be better to invest in the existing facilities in Bosnia and Herzegovina, so that we can represent ourselves as someone who cares, truly cares about the archives, and only then can we talk about potential transfer. It is my honest desire to return the materials to Bosnia and Herzegovina, but objectively speaking, we currently have no conditions to do that. And let me say that this is a topic requiring a conference of its own, which would gather experts from various countries, from the region, from the world, who would talk about the accessibility to the archives of the ICTY and their future. The professional community should have the last word here in the region about this. Thank you. I think we should wrap up. We still have to hear the closing remarks, so please bear that in mind. Good afternoon. I was not here all the time during this conference, so I hope I will not jump to another topic. An hour and a half or two ago, I was here when the representatives of the tribunal talked here, and they referred to ownership, meaning someone owning something. The three constituent peoples of this country, if they were able to agree on ownership of things, then we would not need the ICTY to start with. So I would like to ask the tribunal and the international community to include in their exit strategy all mechanisms available to ensure that the prosecution for war crimes in Bosnia and Herzegovina and in the entire region does not stop once the tribunal closes its doors. That would be my message and my demand, I would say. I demand the tribunal not to leave us. Had there been an intervention in 1992, we wouldn't have needed the tribunal. The tribunal was a remedy for a consequence that could have been prevented. I'm conveying this message to the tribunal representatives and the UN Security Council and everyone else. It would be cynical to leave things half done, even though the achievements of tribunal are immense, with 161 completed cases, and we are truly grateful for their work and efforts. We know that it is the problem of the local contexts and people, but it is cynical to say that we should take over ownership over the problem that is not ours, ours alone. The crime against humanity is not the crime against Bosnian Serbs and Croats only. It is the crime against humanity, and you are a part of that humanity. Thank you. I believe this perfectly concludes the work of this panel. If the panelists have anything to add, I will now invite them to do so. I completely support the remarks made by our last speaker. No one can deprive us of the ownership over the materials kept in the archives. The archives help dealing with the truth and the past, and enable progress and reconciliation in this country, and they should be used and that is what we should think about, and that is something we should work towards. What happens with the archives in the end, we will see. But for the time being, it seems to me that it is important to use the materials with responsibility for the better future of these people.
Well, I can only support, and I'm really glad about the remark of the professionals, and I think it's really an issue that must be further discussed. There are a lot of details about originals, about artifacts, what happens with them, and I agree, a lot can already be used even before these questions are resolved.
I absolutely agree with colleague Živanović when it comes to the transfer, but let us draw a distinction here. It is one thing that we have publicly available documents, the copies of which we need as soon as possible to start the process of dealing with the past in formal and non-formal education. When I say formal education, I'm referring to the establishment of legal clinics at law schools that would use these materials for educational purposes. In non-formal education sector, there are very good initiatives by non-governmental organizations organizing summer schools and academies for young adults and youth, where the materials could be used for educational purposes and also for research and scientific work that would prevent that these materials are forgotten. The second issue is the issue of the transfer of originals, which will be very difficult to resolve given the decision of the UN Security Council. But as a person from the educational sector, the most important thing for me is to put these materials to use as soon as possible to the judiciary, to finalize the proceedings, and so on. The issue of the transfer and the issue of the originals is a parallel process, but it is a separate issue. Thank you.
So just to close, I'd like to say you can at least be confident that the archives will be properly preserved by the United Nations. That is one of the mandated responsibilities of the MICT, to preserve the archive. The main focus that we have on the archive is access. And I have to point out that really most of our public material is already available to you through the website. So you do have access. The whole idea of information centres is to try and make you make better use of that material that is available. The statute of the residual mechanism also, as I earlier said, puts an obligation on the mechanism to assist national judiciaries that are seeking access to confidential material. So requests can be made like they're made now by the courts for variants of protective measures. And there are certain conditions that have to be met, but provided they're met, that material will be available for local courts. Thank you.
I can only thank you all for the remarks you made. You are the final beneficiaries of this. I followed this dialogue related to the archives, and I believe that it is in your interest to make suggestions about how to make the best use of the archives and how to enable access to those materials. Nerma is here. Thank you, panelists, and thank you, Mr. Osorio. I would like to thank you all who stayed here until the end.